Well, thank you very much for that kind introduction. I promise to send you a shorter bio next time. Well, it's great to be here. I thought we were going to have a very small little panel discussion, but one of the advantages of arbitration is its flexibility, so we can change on the fly when we need to. We've heard a wonderful keynote speech this morning, and I just want to say amen to everything we heard. And when you think about the Russian sanctions that were imposed by the United States on the basis of a lawyer who died in custody, I always sort of tell my U.S. friends, what would you think if Russia started sanctioning the United States for what's going on in Baltimore? You know, would that make sense to you? And it sort of puts it in a bit of perspective. So I really enjoyed this. Although I'm an American, I hope there's no recorders in the room. Although I understand from Mr. Snowden that there probably are. Right. So we are all being forced to deal with this issue, and I think the KLRCA is uniquely positioned to address it, and it's rapidly emerging as a leading arbitral institution. It's strategically located in a neutral jurisdiction, and I think this conference is a testament to the vision and the strategic thinking, strategic vision of the KLRCA in addressing this issue. So I thank you for having me. I'm proud to be here. It was so important to me to come that I'm missing my wife's birthday. So, no. That's not a good thing. I will face severe sanctions when I get home. I may seek asylum in the... So there are three main things that we're going to be addressing in this conference. Are disputes arising from sanctions arbitrable? This will be discussed this afternoon. How will we apply the sanctions as governing law in the context of arbitrations? And how should arbitration centers and arbitrators deal with this issue, with issues arising in the context of sanctions? And I think we'll probably focus, from my perspective anyway, from the arbitrator's perspective on this third question in the brief time I have. Now, I live in Korea, as was mentioned. I've been there on and off for 25 years now. I've also spent time in other jurisdictions. I'm in the United States, the country that is probably the most to blame for a lot of the problems we'll discuss today. I'm sorry. But as we saw this morning, the people in the jurisdictions affected by sanctions are on both sides of the fence, right? I mean, I sometimes feel that the sanctions that are in place are applied to me, you know, because I have a case that where this is a live issue, so I'll be careful what I say. But where there are, for example, Russian parties involved in an arbitration. So we're all having to deal with this. Our panel was called The Nature and Effects. I think we all know the nature of these sanctions. They're, as Tony described, sort of laying economic siege to the target, freezing assets, restricting trade, limiting access to capital and credit, prohibition of providing certain types of goods or services, travel restrictions and the like. They can be quite serious. They can be quite debilitating, right? But what are the effects of these sanctions on international arbitration? We heard the sort of schoolyard bully analogy this morning, and I think it's really in the shadow of schoolyard bullying that we find ourselves, because we have this entity that is trying to impose sanctions on from the public interest perspective, as Patricia pointed out. But we are here trying to do our private economic business under the shadow of that, and where that affects us is where the nexus lies. So. We're all victims in a sense, if I can play the victim card. So these sanctions will inevitably have impact on international arbitration. And I'll focus first on just two aspects. One is on future contracts which have not yet been concluded, and the other is on contracts which have been concluded and have an arbitration clause. So for contracts that have not yet been concluded, they may discourage people from doing business with each other, which I think is always problematic. But assuming that they are going to do business together, the parties will choose a neutral governing law. Because obviously, and I think we'll hear more about this later in the day, if you choose a governing law which contains mandatory provisions relating to the impositions of sanctions on certain individuals or countries, then that is included in the governing law that you've chosen. For Russian-related contracts, for example, this means that the long-favored resort to UK law will be over. I mean, a lot of contracts have been governed by UK law. Russian parties may be looking for something that is familiar but not that does not include this element, and common law jurisdictions like Singapore and Malaysia may be able to benefit from that. Likewise, they will seek neutral seats. This is very important because the law of the seat obviously determines the procedural law and the substantive law with respect to issues of setting aside the award and public policy basis for setting aside the award. And as we've heard this morning, these EU and US sanctions are pushing Russia away from the West and toward the East. Russian disputes will leave places like the UK and Stockholm and Paris and go to Kuala Lumpur, Singapore, Hong Kong, Dubai. Third, the parties will seek neutral arbitrators. I'm a US citizen. Does that mean that I'm conflicted? Does my citizenship give rise to reasonable doubts as to my impartiality and independence? Does my citizenship cause problems with respect to enforceability in the jurisdiction facing sanctions, or, in fact, my own jurisdiction, if that were to become an issue? And, of course, the parties will seek neutral arbitral institutions. This is very closely tied to the seat, of course, because the institutions are generally governed by the law of their jurisdiction. The LCIA and SEC and ICC may lose ground to institutions like the KRCA or SIAC, HKIC, DIAC in Dubai. Now, for current contracts that are already concluded and have an arbitration clause, there will be issues of non-performance because of the interference of sanctions. I think that's the most obvious issue, with one party saying that now I'm not permitted to perform this contract, or a party from a sanctioned jurisdiction saying that I'm unable to perform this contract because of the sanctions. Now, in the EU regulations, it says that a target party cannot raise a claim of breach on the basis of a party non-performance of a party due to a requirement under this EU regulation. This is the sanctions directed at Russia, but they can seek judicial review as to whether the non-performance is related to the sanction. So the performance is by a party is excused, non-performance is excused, but you can seek review as to whether it should be excused because of the sanction. And the party seeking to prove that performance should not be excused would bear the burden of proof, which hardly seems fair. But we'll come back to this when we talk about the role of arbitrators. It shows, again, the importance of choosing the governing law, but it also shows that other laws may have an important effect, even where extraterritoriality may not even be intended. I have an example of a contract governed by Russian law to be performed by an EU entity. The EU entity could face severe penalties for compliance with the contract. In some cases, prison may even apply, and I think particularly under U.S. regulations, or very severe fines. So I think although arbitrators would not be bound by sanctions where the governing law is not the law of the sanctioning state, and the seat is not in a sanctioning state, they may also have to consider the effect of laws applicable to the parties and to the arbitrators themselves. There are also practical issues that arise. I mean, travel bans, how can you get the parties to the hearing? Lack of access to funds to fund the arbitration. These all may present difficulties for tenants at the hearing, even where the seat is neutral. Where the seat is in a sanctioned country, would I be able to, for example, to go and sit there as an arbitrator and travel there and spend money there? Where it's a sanctioning country, would the sanctioned entity be permitted to travel there for the hearing, et cetera? So all kinds of issues can arise. I've already alluded to setting aside an enforcement. An award could be set aside in a sanctioning country on the basis of public policy, and enforcement likewise, in trying to enforce the award either in a country that's been sanctioned or a country that's sanctioning their public policies. Issues could arise. Now, from the perspective of an arbitrator, I think there's several issues that arise, and I'll just touch on them very briefly. One is, of course, the question of conflicts, which I alluded to earlier. Is there justifiable doubt as to my independence and impartiality? Could I be pressured by my government to find a certain way, or may people have some reasonable perception that I could be pressured or biased? I think that has to be taken into consideration. My liability as an arbitrator, am I violating any sanctions by sitting as an arbitrator involving a party that's a Russian or Iranian party, for example? Am I allowed to be paid by such an entity? These issues all raise their ugly heads. We're going to hear in more detail. Well, let me go to the impact of sanctions on contract claims and their arbitrability. Although we'll hear in more detail from Oves briefly. So, to the question of, is the effect of a sanction arbitrable in a dispute between private parties which has arisen, in which non-performance is justified by the sanction? I would say that it is, and I realize that may not be a unanimous view. But the reason I say that is even under the law of the jurisdictions imposing the sanctions, this is subject to judicial review. And so it's not enough to say that I can't perform because I'll go to jail if I do, and then that's the end of the story. I think the tribunal can have the same remit and ambit for review of that issue as a court would. What if the non-performing country is not from the sanctioning country, but they've just chosen, the parties have just chosen UK law, for example, as the governing law? Is the arbitrator bound to apply the sanctions to parties who would not otherwise be bound by that because they've chosen that as the governing law? Interesting question, which I will not answer. I'll leave for discussion. How are we going to treat sanctions as an excuse for non-performance? And this is what Oves is going to talk about in more detail. Is it force majeure? Is it impossibility? Is it frustration of purpose? What about the potentially devastating consequences for a party who does perform? So those are considerations. I think Patricia has laid the ground very thoroughly for us, so I'll skip my next bit, but just say in conclusion, sort of echo some of the statements that were made, I think, by Tony. I had an analogy that was slightly different from the schoolyard bully, and that was that sanctions are a bit like drones. They're very easy to launch, and you think that you're going to do this and not hurt yourself. You're going to be safely away, but they're very imprecise. They hurt many more people than their intended targets. Usually the poor suffer far more than the intended targets. They're of questionable legality and questionable morality, I believe, and they end up usually creating more problems than they solve. And as we've seen, sometimes even U.S. citizens are the target of drones. So all of these analogies are imperfect, but I just throw that one out there. I want to commend the KLRACA for having this discussion and for taking advantage, I think, of the opportunity to serve parties who find themselves the target of these kind of sanctions. to give them a venue for the resolution of the disputes. Because after all, at the end of the day, even among our friends and our enemies, what we want people to do is engage in the amicable resolution of their disputes by arbitration. Thank you very much.